Okay, good afternoon. Thank you all so much for being here. I am Rose Pondell, and together with Ellie Javadi, who's also here, we are co-chairs of the Family Formation section of the Beverly Hills Bar Association. And we are so happy to be here today with Amira Hazenbush, who we both have the absolute honor of working with. And I am so sorry, my computer froze on her bio, so give me one moment while I pull it back up here. Amira is the founder of All Family Legal. She works with people from all ends of the LGBTQ spectrum. She has a thriving practice located in Los Angeles. Prior to starting her practice, she spent 5.5 years as a policy fellow for the Williams Institute, where she did research and published reports on LGBT law and policy, including discrimination based on sexual orientation and gender identity, family issues for transgender parents and children, and the legal needs of people living with HIV. Amira went to UCLA School of Law. She got her JD, and she also received her MPH from the UCLA School of Public Health and her BA from the University of California, Berkeley. She is going to give us a great presentation today about how families are created on all different, with all different families, all different types of family formation. Just a couple housekeeping announcements about MCLEs today. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in your BHBA Plus, the members only community for BHBA members. So, and also please take a moment to complete the survey that is included with your certificate. And Amira, we are so excited to hear everything you have to say. And I feel like even though we get to work with you every day, we're going to learn so much from you today. So I will let you take it from here.
Thank you so much for having me. I did mention before you all got here that I always think that this is more interesting when there are questions and answers throughout. I can talk to you for a block of time, just me droning on, but it's probably nice if you all get your questions in throughout. So if you have questions, I'm going to try to keep an eye on the Q&A, and everyone else will as well, so that I can answer them as I go. So I'm going to start with some sort of more basics and try to build up from there. If at any point I've skipped over something that you think should have been answered, that it's not clear, again, don't hesitate to put something in the Q&A so that I can slow down and make sure that I'm reviewing everything. So just starting with what is LGBTQ. LGBT or LGBTQ stands for lesbian, gay, bisexual, transgender, and the Q can stand for queer or questioning, and plus because there can be people who identify within sort of that community without using those specific terms. There are always many names and words that are getting used and changing. So the language changes constantly, but those are sort of the major letters that people use. And I want to take a moment to explain the difference between sexual orientation and gender identity. Sexual orientation is who you are attracted to. Gender identity is the gender that you identify as. So if you are attracted to people of the same sex, generally you will identify as gay or lesbian. If you are attracted to people of both sexes, you might identify as bisexual. And if your gender identity is different from that was assigned at birth, then you would be transgender. So for example, if you were assigned female at birth, but you identify as a male or you identify as non-binary, you might also identify as transgender. A term that not everybody knows is cisgender. So for people who were assigned whatever they were assigned at birth is also their gender identity. So for example, I was assigned female at birth. I also identify as a woman. So I would define myself as cisgender. So cisgender is sort of the opposite of transgender. It's just really important when you're working with clients not to make assumptions about their gender or sexual orientation and to let people self-identify. Even if you see a different sex couple approach you, more than half, so I used to work for the Williams Institute, which does a lot of demographic research on the LGBTQ community. More than half of the LGBTQ community actually identifies as bisexual. And despite that, many, many, many bisexual people are in different sex relationships, because if you're out in the dating world, there are more straight people out there than gay people. So your odds are just higher that you will end up in a different sex relationship. So even when you see a couple in a different sex relationship, that doesn't necessarily mean that both of the people in that relationship are straight. Even if you see a couple in a different sex relationship, that doesn't mean that both of the people in that couple are cisgender. There are lots of transgender people out there who are not visibly identifiable as transgender and won't necessarily disclose that to you up front. That doesn't mean that it doesn't exist. And I always tell people, only ask if it's relevant, and remember to ask if it's relevant. So, someone's sexual orientation may be completely irrelevant in your practice. I'm assuming that most of the people on this call are family law attorneys, and that sexual orientation may be relevant for a lot of our cases, but it might not necessarily be. If you have a different sex couple who's divorcing, it really doesn't matter if one or both people identify as straight or bisexual or pansexual or something else. It really doesn't matter. You're just doing their divorce. At the same time, if you are dealing with, a name change or something like that, where someone's gender identity may also be affirmed in the process, then you are going to need to know these things. So allowing people the space to answer those questions or to self-identify is really important, and also allowing people to not identify if it's not relevant. They really don't need to. It's not, when I meet somebody on the street, I generally don't ask, who are you seeing, and tell me about the people you sleep with or what's inside of your pants, right? It's not really any of my business unless it's part of my business. So I really try to, only ask those questions when needed, but make sure that there's space for that. Also, it's important to not assume monogamy. In a lot of our cases, we're dealing with reproduction, assisted reproduction, and third parties getting involved. And we often have to talk about people's sexual practices when we're talking about preventing STDs. And so we have to be asking questions about, are you in an exclusive relationship with anyone? Are you sexually active with a partner, with more than one partner, and making sure that your contracts and agreements are inclusive enough that whatever sexual practices we're asking people to engage in or refrain from in order to, safely move forward with assisted reproduction, that the language would apply even if the people are in a non-monogamous relationship. And that can include even married couples. There are plenty of open marriages out there, and there are plenty of people not talking about being in open marriages out there. So it's just really important to make sure that your language is inclusive, and maybe they don't need to disclose it to you. You just need to make sure that whatever information you're imparting and whatever you're putting in their contract is going to be inclusive of that. So today we're going to really focus on LGBTQ family formation. And why is this important? Well, the Williams Institute estimates that between 2 and 3.7 million kids in the United States are being raised by at least one lesbian, gay, or bisexual parent. And about 200,000 of them are being raised by a same-sex couple. And those numbers were from 2014. I can guarantee you they're higher now. As we know, acceptance for LGBTQ families and individuals has grown in leaps and bounds in the last decade. And we know that more and more LGBTQ people, especially younger people, are intending to become parents within some form of a queer relationship or a queer identity. So, there are going to be lots of kids out there being raised by LGBTQ parents. So let's talk about how they come to be. So let's start with just, how can someone become a parent through, if you're either single or in, some form of a queer relationship. So probably the one that most people think of is adoption. Certainly people can adopt, unknown children from outside the family or adopt family members, if there is a need within a family. For many gay male couples, and for the sake of simplicity, I may say gay men or lesbians, even though that could include bisexual people or trans folks of different stripes and colors and shapes. Sometimes it's easier to just use the shorthand, which is a little easier to picture. So for many gay men, they will go through both egg donation and surrogacy, because neither of them is able to provide either eggs or a uterus in the process of having children, but either partner could provide the sperm so that they can have children. For many lesbian couples, we'll see them using sperm donation, and one will carry the pregnancy. Sometimes you can see what's called reciprocal Ivf, or reciprocal in vitro fertilization, where one partner uses her eggs, the other partner uses her uterus, and there's sperm from a sperm donor. So they'll actually retrieve the eggs from one partner, do the IVF process, and then transfer the embryo into the other partner to carry the pregnancy. And so then you actually have two partners who are both biologically related to the child in some sense, one genetically and one gestationally. And LGBTQ parents can still become parents the old-fashioned way. There are lots of LGBTQ parents out there who are parents through sexual intercourse. And that may be because a person was previously in a different sex relationship and had a child within that relationship. It may be that the couple may identify as queer but be two bisexual people who have the body parts to be able to have children through sexual intercourse. There are a lot of different ways that queer people can become parents, even without the use of assisted reproduction. So I just want to remind people that there are lots of people who are non-adoptive, non-assisted reproductive parents to children in the LGBTQ community. So one of the first questions that I get a lot, particularly from my lesbian couples, if they're married, is, I'm on the birth certificate, so I'm done, right? That's a very common misconception, and it's an understandable misconception because in the vast majority of times, logistically, what you use to prove your parentage is the birth certificate. But a birth certificate is not entitled to full faith and credit under the US Constitution. So Article 4, Section 1 of the US Constitution, I will do a little reading time for you, is the full faith and credit clause, which says full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. So the way that this has been interpreted over the years is that a judgment from one state absolutely has to be recognized in every other state in the country, no questions asked. You may have to domesticate the judgment, which I'm sure many of you have done for out-of-state child support orders or things like that. So you may have to domesticate the judgment, but the judgment itself has to be recognized here. An administrative act, though, is not entitled to the same recognition across state lines, especially if a state finds that the law that is administering that administrative act is against that state's public policy. So the easiest way to think about this is pre-Obergefell. So Obergefell was our Supreme Court case that said marriage is a fundamental right and everyone gets it, marriage equality across the country. So before that, a couple could get married in California and move to Alabama and say, okay, we're done, we're going to get divorced. Well, Alabama might say, well, we're not going to divorce you because your marriage is against our public policy. We don't have to recognize it here, and we don't. So congratulations, you're not married because we don't recognize it here. Or let's say they didn't want to get divorced, but they moved to Alabama and they wanted to take advantage of one of the rights of marriage, maybe health insurance for a partner through their work. Well, they wouldn't necessarily have to recognize that spouse because the marriage itself was an administrative act and not a legal judgment. And so if they said this is against our public policy, we don't have to enforce it. So Obergefell didn't say, hey, we have a full faith and credit clause issue here and administrative acts need to be recognized from state to state. What Obergefell did was say marriage is a fundamental right and everybody gets it. And constitutionally, this is a problem. And so everyone has to provide for same-sex marriage. So we fixed the problem for marriage certificates, but we didn't fix it for every other administrative document that exists in the world. And so we do not have parentage equality, even though we have marriage equality. And so a birth certificate still does not have to be recognized in the same way that a marriage certificate does. And so you can have two people on a marriage certificate and they can go to a state that doesn't recognize both parents, and we're going to have a real problem if they don't have a judgment protecting them. And if you think this is just sort of a theoretical concept and something that's fear-mongering, just last year, the Idaho Supreme Court, in a case called Gatsby versus Gatsby, actually held that a non-biological mother who was on the birth certificate was not a legal parent to her child. They had gone through a sperm donation. They both signed the sperm donor agreement. They both were on the birth certificate. They were married during the pregnancy and birth. And the Supreme Court basically said, listen, you don't have a judgment. And so we don't have to recognize the non-bio mom. And now the non-biological mother who was raising that child since birth is a legal stranger to her child, which is an incredibly sad outcome. So it's really, really, really important to have a judgment that protects your parentage. Now, in the state of California, we do have a streamlined adoption procedure for married same-sex couples who have a child within the marriage. Usually it's for lesbian couples. There is now an additional provision for some surrogacy cases that's a little more complicated than I want to get into today, but generally it's used by lesbian couples who are using a sperm donor. And there is no hearing, there's no home study. You send a bunch of paperwork into the court reviews it, and as long as it's, stapled and checkboxed and signed and notarized properly, and they're happy with the way that it was sent to the court and that everything's there, they just sign, stamp it, and send it back, at least in the county of Los Angeles. And there are a smattering of counties out there that will still ask for a finalization hearing, but the vast majority will do it exclusively on the papers. It feels almost like an administrative process because it's only paperwork. But it is then a judicial order that has been reviewed by a judicial officer and signed, and is a certified judgment from a court of law. And that is what protects people when they cross state lines. So it's really, really important to make sure that you have that judgment for your clients. Now we'll talk about other ways as we get further along in the conversation, other ways that you can also protect clients if they don't fall into this category, where they can do a streamlined, what I like to call a confirmatory adoption. And just in case you hear other names for it, some people call it a second parent adoption. Some people call it a step parent adoption to confirm parentage. Some people call it a streamlined step parent adoption. There's a lot of names out there for it. I like to call it a confirmatory adoption because in California, they would legally be recognized as parents. And this is just confirming the parentage that, we already recognize here in the state. But biology, in case it's not clear already, is not always determinative of parentage. So we've already talked about that there's this procedure for married couples. The reason that we have that procedure is because there are marital presumptions under our law. So if you check out Family Code section 7611, in particular subsections A through C, talk about the presumptions that if a child is born within a marriage, it is presumed to be the child of both of the spouses. And that holds even if it is absolutely known that one of the spouses is not the biological parent to the child. So we have this protection of the marriage itself. We also have holding out presumptions under the law. So Family Code 7611D says, if you take a child into your home and you hold them out as your natural child, you can establish yourself as a parent. So even when we have an unmarried couple, if one of them is, not a biological parent, but is holding out the child long enough, and has been raising the child and living as a parent to that child for long enough, you can establish yourself as a parent under 7611D. It's important to note here that there are times when biological parents may get boxed out of being legal parents because of other marital presumptions. So for example, and this happens sometimes with straight couples, if a woman is married and meets a new partner and has a child with that new partner, we have that conclusive if she's, living with her husband, or even if she's not, the husband's going to end up on the birth certificate. And if you don't sort of deal with that right away, the partner and the biological father will only be able to establish his parentage under a holding out provision, even though he's the biological father. So there are sort of these complicated things that can come up if we're not careful. And of course, there are the statutes regarding assisted reproduction. So Family Code 7613 really focuses on the assisted reproductive rights. And basically you can consent and give your intent to be another parent. And the code says if you consent to another person being inseminated or using donor eggs or sperm or using assisted reproduction with the intent of becoming a co-parent, and the two of you do that in writing, then you should be treated as the natural parent of the child. So we have a lot of ways to become parents in the state of California. And I just want to point out, because I think a lot of people don't realize that it's there, Family Code section 7613.5 gives a whole bunch of statutory forms. So if people say, we want to co-parent in this way using assisted reproduction, I usually would recommend that people go to a family formation lawyer and get an individualized sperm donor agreement, egg donor agreement, whatever kind of agreement they need. But if they are really tight on money, or if their case is extremely simple, there are these statutory forms that are legally sufficient. They're in the family code, so they can be used. So there are 4 forms. One is an intent to co-parent form for a married couple. One is an intent to co-parent form for an unmarried couple. There's a reciprocal IVF form. So again, that's when one of the intended parents is using their eggs, the other is using their uterus, and they're probably using donor sperm to create a child who is intended to be a child of both of the partners within that relationship. And then the 4th form is a gamete donation form. So there's a section if you're using a sperm donor, there's a section if you're using an egg donor, and then there's still an additional section if there's a non-biological parent who's intending to be a parent to sign on, and everybody says, yes, we're intending for these 2 people to be parents and for this person to be the donor. So all of those forms exist. And if I talk to clients who are, oh, I think there's a question.
Oh, I have a question, Amira.
Uh-huh.
Have you found that those clients who they're working through a clinic, do the reproductive endocrinologists accept those forms, or are they still, pushing back and needing an attorney to be a part of it? Because that's a whole other layer
Right.
that I think some people probably aren't aware of on this call too.
Right. That's a great question. And it really depends on the reproductive endocrinologist and what the clients are doing. So usually the most common times that I see people using these statutory forms are when working with a sperm donor and doing an at-home insemination, which, by the way, in case you haven't been keeping track of the sperm donation law as of 2016, people can do sperm donation without medical intervention. And as long as there's a written agreement, that will be an enforceable sperm donor agreement. So you don't have to involve a doctor. But if you do, there are many doctors who will say, I need legal clearance from a lawyer. They kind of want to CYA and make sure that they are being covered. And so they may require that, even though there are these technically sufficient statutory forms. What I was actually, Ellie, this is a great transition into what I was going to talk about, which is what those forms don't do and why it's not always advisable to just rely on those. They don't handle anything with egg, sperm, or embryo disposition. So usually when you're working with a reproductive endocrinologist, you are going to end up with frozen sperm, frozen eggs, or frozen embryos, or some combination thereof. And then the question becomes, well, what happens if you have leftovers, right? What if you've had as many children as you want and now you have extras? What if you're a couple and you break up and you've got gametes on ice? What if one of you dies? What happens to them? What if both of you die? What happens to them? What if your donor passes away? Are you still allowed to use them? And so all of those questions can be answered in a sperm or egg or embryo disposition form. And so for my sperm donation agreements and egg donation agreements, they also have disposition language that says, here's what happens under all of these different circumstances. And so a clinic, legally, they are required by the state of California to have their own clinic disposition forms, but those are usually a check the box kind of situation that people may read over very quickly. And, a clinic may say, look, for a husband and wife couple that are using their own eggs and sperm, we're just going to let them check the boxes and move on. But if there's going to be a third party in this reproductive process, we're going to ask for a lawyer to make sure that this has really been done in more depth. So, certainly people can ask the clinic if they can use those forms and the clinic forms as enough, but I can tell you that even the clinic forms, I do consulting on some of them, and it's really hard to get a check the box kind of form that is going to be enough to cover all of the different scenarios and situations that may be out there. And so most of those clinic forms are going to be lacking in one way or another if they're not taken through the legal process and individualized to each set of intended parents or individual intended parent. So it's really important for people to read those forms carefully and to talk to a lawyer if they're not sure or if they want to add something to them. I tell people all the time, just because something's printed out on a piece of paper doesn't mean you can't scribble over it and change it and make it what you need it to be. But most people who are at an IVF doctor are not really thinking about what's going to happen in a few years when we've got frozen leftovers, right? They're thinking, I want to have a baby right now. And so it's a little hard to get people to slow down, which is why I don't think it's a bad idea that some of those reproductive endocrinologists will say, we need legal clearance. We need to hear from a lawyer that, yes, you're ready to move forward on this. Do we have any questions in the Q&A at this point? Okay. So I want to move forward a little bit into talking about a voluntary declaration of parentage. So many of you as family lawyers are probably familiar with the voluntary declaration of paternity. So historically, we made the voluntary declaration of paternity so that an unmarried woman who knew who the genetic father was and who had a genetic father who was willing to acknowledge his paternity could both sign off on a form together. And then he would end up on the birth certificate. And if she ever needed child support, it was treated like a parentage judgment and they could just go straight after him for the child support, right? The idea was to make it easy to get child support. But lots of queer families who were having children said, well, why can't we sign this? We are willing to acknowledge our parentage and we're willing to be on the hook for child support. That's part of the process of what we're doing here. So in 2020, they did actually change it from a voluntary declaration of paternity to a voluntary declaration of parentage. And the key family codes are sections 7570 through 7574. You can also look at Assembly Bill 2684 from 2018. That was when they added all of the language to allow it to take effect in assisted reproductive procedures. So it's still, we still have the ability for an unmarried woman who has a child through sexual intercourse to have the biological father sign off on the form. But now it also allows either a married or an unmarried person who's giving birth with another intended parent using assisted reproduction to have that other intended parent sign off on the form. And that should be enough to get them put on the birth certificate. That being said, I think it's getting better. It's been 2 years now, so I think we'll see more and more acceptance of the form. I had some clients who gave birth in like February of 2020, and I was like, well, you can tell the hospital that you should be able to sign this, but they might not be up to date on the procedures yet because it's very new. So you may want to make sure that you have other things in place to protect your clients in case they can't sign the voluntary declaration of parentage right away. Now, here's the interesting thing about a voluntary declaration of parentage. There are certain ways that it can be voided, either in a certain amount of time after it's signed, or if things weren't correct at the time it was signed. So for example, if the person is married to somebody else who was not signing, if there's already a parentage judgment, there are different ways to void a voluntary declaration of parentage within certain time periods. But assuming that there is no reason to have it void ab initio or voided later on, section 7573D of the Family Code says, a completed voluntary declaration of parentage that complies with this chapter and that has been filed with the Department of Child Support Services is equivalent to a judgment of parentage of the child and confers on the declarant all rights and duties of a parent. So we have this language here, equivalent to a judgment. So I want you to go back to what I was just talking about with the full faith and credit clause, where a judgment gets full faith and credit across all states in the United States. But what about a voluntary declaration of parentage that is equivalent to a judgment? It's this very open question. It's this huge gray area where it's supposed to be given the force and effect of a judgment. So it should be enough across state lines, but it's not a judgment. There's no judge signing off on it. There are no certified copies coming from a courthouse. It's an administrative procedure that is supposed to be given the force and effect of a judgment. So will that be enough across state lines? That's an open question. We don't have any appellate law on that at this point. What I can tell you is that in Gatsby versus Gatsby, that Idaho Supreme Court case, they did mention that she did not sign a voluntary declaration of parentage. So it seems like they would have accepted that if she had signed it. So there may be a day when it becomes very clear that a voluntary declaration of parentage is legally sufficient, and that will save a lot of families a lot of time and money because they won't have to do a confirmatory adoption. The voluntary declaration of parentage could potentially in the future be declared to be entitled to full faith and credit across the country. Now, that being said, a lot of assisted reproductive attorneys work with clients from all over the world who have some sort of connection to whatever state they're in the United States. And a voluntary declaration of parentage is not necessarily entitled to comity across countries. And so if you're dealing with any clients who may currently live out of the country or may in the future live out of the country, sometimes you might still want them to get some sort of confirmatory adoption just because the term adoption is so universally recognized and easy to understand. And so even though it may be the right decision for some families, you really need to do an individualized assessment to figure out what's going to be the best choice for everyone. And then, so we've talked about confirmatory adoption, we've talked about voluntary declaration of parentage, but I also want to talk to you about a parentage judgment. So again, if most of you are family law attorneys, it's probably not unheard of that you will file a petition to establish parentage. Usually we do this when an unmarried couple who has a child together is splitting up and you need to figure out custody and child support and all that kind of fun stuff. But you can also use a parentage judgment before the child is born to establish parentage, or after the child is born to protect the parentage that was intended by the parties. So this is often used for unmarried same-sex couples through surrogacy, through sperm donation. It's also used for surrogacy. So our parentage judgments for surrogacy have their own sort of quirks that they have to follow. Surrogacy parentage judgments have to be uncontested and responded to, whereas other parentage judgments can be stipulated default. But often for my unmarried same-sex couples who are using sperm donation, the tool that we use to protect them is a parentage judgment, because again, you still get that judgment. So we don't have the confirmatory adoption procedure available for unmarried couples. So that's often what we use. I'll talk later about how we would also use that for single parents. I want to take a little bit of time and talk about the special needs of transgender clients. Still not seeing any questions. Don't forget, you can ask questions throughout. Transgender clients may have a lot of different concerns that they are dealing with when trying to build their families. So first of all, it's important to note that not every transgender person or gender non-binary person will undergo medical transition. So medical transition is where you undergo some sort of medical procedure, whether it can be big or small, to make your physical appearance align with your gender identity. So especially for many non-binary folks, they don't necessarily feel the need to alter their bodies in any way. And so there might not be any medical change. But for those who do undergo medical change, whether that's hormone therapy or some sort of surgery, that can have an impact on someone's reproductive capacity. And so there's often a conversation about preserving their fertility before undergoing transition to make sure that they have those options later on. I do see that there's a hypothetical. I will come back to that. So if you have a person who is going to be undergoing hormone therapy or something else, in the same way that before somebody undergoes chemotherapy, they may be thinking about freezing their genetic material, that may also be a consideration for a transgender person before they undergo hormone therapy or other transition-related medical care. Now, as we're seeing more and more kids come out as trans at a younger age, that is a more complicated conversation to be having with a 12-year-old or a 16-year-old who may be going on hormone blockers or thinking about cross-sex hormones as a teenager, as opposed to somebody who's 23, 24, 27, 35. So these conversations are going to get more complicated as we're dealing with trans youth, but it is an option that people may want to consider before they transition, with the understanding that, as many of you know, a lot of fertility coverage, a lot of insurance does not cover most fertility care. And so the ability to preserve your genetic material may be limited. Now, that being said, and I didn't double check this before our talk, but I believe that there is some requirement in California that fertility preservation must be allowed for people undergoing cancer treatment. And there is also, and I'll talk about this in a little more detail later, there is a requirement under the Insurance Code of California, under our regulations, that there can't be discrimination based on gender identity. So you can't discriminate, you can't treat somebody badly because of their gender identity, you can't refuse to treat someone because they're transitioning, and you also can't choose not to provide a service or not to insure something because it is related to gender identity if you already provide that service for other reasons. So for example, if you provide hysterectomies for other reasons, then if a person needs a hysterectomy for their transgender care, that also needs to be provided. So I think that if there is this requirement that there has to be fertility preservation for cancer, and I'm literally just thinking of this as I'm talking, there could be an argument that then there would also have to be that same preservation available for trans care. It's an argument. I've never heard it made before. I literally thought about it while we were talking right now, or I was talking right now. But the coverage and all of these things vary by insurance, and the ability to pay is obviously a limitation in this. That being said, it's important to know that there are still physical abilities, reproductive capacities often for many transgender people. And so just because someone has undergone hormone therapy doesn't necessarily mean that they can go off of, birth control. I've definitely heard of cases of transgender men, and just in case it's not clear who a trans man or a trans woman is. So a trans man is someone who identifies as a man, but was born with female body parts. A trans woman is someone who identifies as a woman, but was born with male body parts. So I have heard of cases with trans men who are on hormone therapy, who, go off of birth control because they believe that they're no longer having reproductive capacity because of their hormone therapy, and then accidentally get pregnant. So it can happen that even when you're on cross-sex hormones, that you might still be able to get pregnant or impregnate someone else with your genetic material. So it's really important that people be talking to their medical providers about what can happen, what can't happen, what they should be doing to allow them to, have a family when they want and not when they don't. And we're seeing more and more often now, for example, trans men who want to carry a pregnancy. And so there are trans men out there who will adjust their medications and work with their endocrinologists to be sure that it's safe for them and for their child. And they will then, actually carry a pregnancy as someone who identifies as a man, but who still has a working uterus and is able to do that. So it's really, that doesn't mean that every trans man is going to want to carry a pregnancy. There are many trans men out there who do not want to carry pregnancies, but it's really important to treat each client as an individual and allow them to express how they may or may not want to have a family. Also, for all of you family law attorneys out there, when you're dealing with a divorce, it's really important to ask people, do you have any genetic material stored? Do you have sperm stored? Do you have eggs stored? Do you have embryos stored? Who owns it? Who wants it? Who's paying for the freezing costs? All of that kind of stuff. Those are really important questions to be getting into. I would assume that most people don't forget that those things exist. I think more often you're seeing couples fighting over them, but you never know if they built a family and, it was stored 15 years ago and they just kind of forgot that it was on ice. They may need to address it now as they're going through their divorce. So it's really important to be thinking about these things. So let's talk about, let me go back to the hypothetical. So married lesbian couple, one woman is the bio mom. Should they file an adoption for the non-bio mom? Yes, they should be doing the confirmatory adoption. So that's what we were talking about, that streamlined adoption procedure. Even if they're both on the birth certificate, you're going to want to have a confirmatory adoption that protects them across state lines. Now, there are some lawyers who will tell them that a voluntary declaration of parentage should be legally sufficient. As I've mentioned, it's a legal gray area. We don't have a clear response. We don't have a clear appellate law decision that says whether a voluntary declaration of parentage will be given full faith and credit across every state. So when my clients come to me, my advice is yes, you still want to have that adoption done. Okay. So let's talk about single parent families and multi-parent families for a little bit. So the law does allow for recognition of more than two parents. Starting in 2016, Family Code 7612C states that in an appropriate action, a court may find that more than two persons with a claim to parentage under this division are parents if the court finds that recognizing only two parents would be detrimental to the child. And then they go on to talk about what detriment means. They say in determining detriment to the child, the court shall consider all relevant factors, including but not limited to the harm of removing the child from a stable placement with a parent who's fulfilled the child's physical needs and the child's psychological needs for care and affection, and who has assumed that role for a substantial period of time. And a finding of detriment to the child does not require a finding of unfitness of any of the parents or persons with a claim to parentage. So we actually now can find for more than two parents prior to birth. We can find for more than two parents at the time of birth. We can find for more than two parents as the child grows up. It all depends on the circumstances. So particularly for clients who are engaging in reciprocal IVF, if you have a lesbian couple and their best friend who's donating sperm, and one uses their eggs and one uses their uterus, and they use sperm from their best friend and they intend to be a 3-parent family, that can now be done in the state of California. We can establish that. Maybe you have a three-person relationship, a non-monogamous three-person relationship where they all intend to be parents together. Again, if you have, genetic material and you have somebody who's holding out, or you have a marital presumption, all of these things can kind of crisscross over each other to create presumptions that allow for more than two people to become presumed parents, and then to allow for them to all legally establish themselves as a three-parent family. So again, you're having to show that there would be detriment to the child to have two or fewer parents. But if you can show that, and you can show that they've all legally established themselves as parents under one of these presumptions, then you actually can have more than two parents. Now, this doesn't mean, if somebody moves into your home and is an uncle to the kid and is just sort of, living there for a little while and providing basic aunt or uncle support, that doesn't necessarily mean that they can petition to become a parent, but it does create more legal gray area than we've seen in the past. So, for example, let me just take a look at this. So, for example, one of the cases that I worked on a few years ago, and this was after we were allowed to have three parents, there was a lesbian couple who decided to have a child together. They were unmarried, and the one who was going to become the biological mom, so she used her eggs and her uterus, she asked her best friend if her best friend's husband would donate his sperm to them, which he agreed to. So we have non-biomom, biomom, and sperm donor who's best friend's husband. So biomom gets pregnant using her best friend's husband's sperm, and she and non-biomom remain in a relationship and raise the child for a few years. At a certain point, they break up and continue to co-parent the child amicably for a few more years. And at a certain point, things start to break down in the co-parenting relationship. Now, they've never done any sort of parentage judgment or adoption or any proceeding to protect non-biomom's parentage rights. And now biomom doesn't really want non-biomom in the picture. Well, in the meantime, biomom moves in with her best friend and her best friend's husband, who best friend's husband, remember, is sperm donor, into the other half of their duplex. So best friend and best friend's husband and their kids live on one half of the duplex. Biomom and child of this relationship live on the other half of the duplex. They go back and forth all the time. The best friend and best friend's husband's kids call the child a sibling. Best friend's husband, who is sperm donor, spends time with his kids on Father's Day, doesn't spend time with the child of this other relationship, but does have family dinners where the child comes over. And I said to my client, you couldn't have made a better law school question if you tried. Is that taking the child into your home if you move into the other side of the duplex? Is that holding out the child as your own if you're engaging in behaviors that appear to many as parenting time, if you're having family dinner together, if you're starting to go on family trips together, if your kids all call each other siblings? Where does this line get drawn? And so my client, who is the non-biological mom, was horrified because essentially biomom was trying to wedge her out and reduce her parenting time, reduce her custody, because she said, well, now there's a third parent who also needs custody time, and we just happen to live together, so we both will get that time together. So it was a really messy case. They ended up finding a settlement that worked for all of them, but the beauty of a three-parent law is that we can now recognize families in many different forms that we couldn't recognize before. The problem of a three-parent law is we now can recognize many families that we didn't recognize before, and that might not have been intended to be recognized. And so it really does create more space to argue, which can be good for the family or bad, depending upon who you're talking to and, your opinion about best interest of the child and the child's own experience and those kinds of things. So we do have this ability now. We also have the ability to recognize only a single parent, but there is a presumption and a public policy preference for a child to have at least two parents. So it's kind of hard to protect single parents. So let's say you have a single woman who uses a friend as a known sperm donor. I would recommend at that point that in addition to doing the sperm donation agreement, that we also do a parentage judgment that brings him in as a respondent, and that we say that he is not a legal parent to a child. There is actually a provision of the family code that says you can file a petition to establish the non-existence of the parent-child relationship for a donor. I believe it's 7630F, but I'm taking that off the top of my head, so don't quote me on that, but I think it's Family Code 7630F. And a really important case to think about that was Jason P versus Danielle S. So this was a case where this was actually not a queer case. It was a straight, as far as I know, straight different sex couple. I don't think either of them identified as bisexual or trans or anything like that. And they tried to have a child for a while unsuccessfully. They ended up breaking up, and they had frozen, I don't remember if it was sperm or embryos, but they had frozen genetic material. And Jason wrote a letter to his ex-girlfriend Danielle and said, look, you're going to be a great mom. I'll be your sperm donor. You can use my sperm and go out and have kids. And she very happily went ahead and did that and successfully got pregnant and had a child. And she and Jason were kind of on again, off again. So, they started seeing each other sometimes, and Jason made a room in his house for the kid, and he started going on the school forms as the father, and he started going on the medical forms as the father. And at a certain point, he sued for child custody. And Danielle said, no, that's not what we agreed to. You're a sperm donor. That was what we had agreed to. You're not a parent. And the court looked at the totality of everything and said, well, he may have started as a sperm donor, but then he turned himself into a parent. He established himself as a parent under 7611D because he took the child into his home and he held him out as his natural child. And so it created this very complex area of space where now people who want to have really sort of intimate, close relationships with their sperm donor are in some respects possibly putting themselves at risk of the donor then coming in and saying that you're going to be a parent. Or on the flip side, the donor, if he allows himself to have this really close relationship with the child, could find the parents going after him for child support at some point. And so, I recommend that people do this parentage judgment. We don't have any case law that says that a person can't turn themselves into a parent under 7611D after a parentage judgment that says that you're not a parent, but it would seem pretty hard to do that after the fact. We do have case law that says that after you've had a termination of parental rights, this was under an adoption and a dependency proceeding. A mother had her rights terminated for abuse or neglect or abandonment, and then the child moved back in with her and she was acting like a parent, and she tried to establish her parentage under 7611D, saying that she took the child into her home and held them out as her natural child. And the court said, no, you've already had your parental rights terminated. You don't get to turn back the clock of time by doing a 7611D action now. So we have that for a termination of parental rights. I think that there's a strong case to be made that a judgment establishing non-parentage should be treated in the same way, but there's no guarantee here. So single parents really have to think about how they are having a relationship with their donors, if their donors are close friends or family members, especially, and theoretically now, because we can have more than two parents, the same reality could exist even for couples, because a donor could claim, well, I'm a third parent to this child. Now, again, you'd have to show detriment to the child. So there is a slightly higher barrier there, but there is the possibility that that could occur. So it's really important for people to understand what a donor agreement can do and what it might not be able to do. There's also a case called KM versus EG. This case was from 2005, and this was a lesbian couple that engaged in reciprocal IVF. So one used the eggs and the other used their uterus to have a child together who they raised together. The one who used the uterus, the gestational mother, claimed that her partner was only intended to be an egg donor and that she was intended to be a sole single parent. And that was what they had agreed to, that her partner was not going to be a parent to these children. And the court said, listen, if you're a lesbian couple who's living together, who's raising a kid together in your household, who did reciprocal IVF, we're going to call you both parents. So, I was not there when they had their initial conversations, and I find it highly suspect that one partner was really agreeing to be an egg donor. But even if that were the case, even if they really had agreed that one was going to be an egg donor and the other was going to be a parent, again, that if that were the case, the egg donor still turned herself into a parent by basically raising the child, taking the child into her home and holding him out as their natural child. So you have these cases that basically show that, people who, if it looks like a duck and walks like a duck and talks like a duck, right, then it's probably a duck. So people who are really acting like parents in every way are going to be able to establish their parentage if they seek to. So it's really important that people understand that and are willing to take on some risk if they want to have that level of closeness and don't want to have a parent-child relationship. Remember, at the end of the day, the courts are going to be looking at the best interest of the child. And so if, you know, if the parent-child relationship exists by action, then it's in the best interest of the child at that point to protect it legally. So they will do that. It's also important to think about these crossover issues with marital presumptions when you have single parents or more than two parents. These are cases where, again, you're kind of living in murky waters where we can't necessarily answer what would happen if you have a married couple and a third person who wants to be a parent with them. So, you know, I'm consulting on a case where there was a 3-person relationship. The child was the biological child of the married couple, and the third partner in the relationship has, you know, been acting as a parent, has been taking the child into her home and holding the child out as her natural child from the child's birth until about 7 years old, clearly has a parent-child relationship with this child. But then the relationship started to break down between her and the marital couple. And, you know, they are trying to block her out of having time with the kid. And I think that she's going to have a much harder time establishing herself because you have both the marital presumption, you have the biology here. And so she doesn't really have the finances to really litigate this. I think that she certainly has enough to establish herself as a 7611D parent, but we also have these other presumptions that are sort of crossing over. And if one of the parties to the marriage, let's say she was only in a relationship with one of the spouses and that person used assisted reproduction and she wanted to be a parent, it gets very complicated. I had a case with a lesbian couple who was married but separated. They had chosen to continue to live together and raise their child together, but they were no longer, in their minds, in a marital relationship. They had separated, and one of the partners had a new girlfriend, and she and her girlfriend wanted to have a child together, but we had to do a full agreement that said, okay, partner B and partner B's girlfriend are going to be the legal parents. Partner A, who is still on the books married to partner B, is not going to be the legal parent. And these things get very complicated, right? Because you have this marital presumption and they were still living together and they were still, you know, in a valid marriage. Nobody had filed for divorce. So there was a marital presumption there, and they were doing everything they could to rebut that through this assisted reproductive technology agreement. So these things get quite complicated. Just checking the Q&A again. It looks like we don't have any additional questions, but I'm happy to answer them. We're getting close to the end of time, but it does look like we have a little bit of time for our bonus, which is thinking about health insurance. So I am not the end-all be-all expert on health insurance, so I'm going to give you a couple of sort of tidbits to keep in mind for your clients to make sure that you're thinking about, and then you can talk to insurance experts to get more details. So the first thing I want to talk about is what it means to prove infertility. So generally speaking, when you ask someone when people are looking for health insurance coverage, they have to show that they have tried to get pregnant for, usually it's 6 months or a year, depending upon the circumstances. Trying usually means having sexual intercourse without any birth control method. But, you know, I have lots of same-sex couples who like to joke, well, it's not for lack of trying, but it still doesn't seem to be working. So, you know, obviously for couples who have the same body parts, you know, they're not going to be creating children without having some sort of third-party assistance. So for lesbian couples, that may mean that they need to be buying sperm for 6 months or a year before they can qualify for additional reproductive assistance. That can be a very expensive way to go. And for same-sex male couples, there's nothing to do but go directly to egg donation and surrogacy. It's not like there's any way to try to get pregnant as a cisgender man. So these infertility issues can be, you know, the definitions and how they are set forth can really end up being administered in a discriminatory manner against same-sex couples. we work often with surrogacy. I didn't talk a whole lot about surrogacy today because it really could be its own complete separate hour to talk about surrogacy, but it is really important when you're working with a surrogate to make sure that her health insurance is going to cover her pregnancy. So generally speaking, if I have a set of intended parents and a surrogate, the intended parents insurance is not what covers the surrogate. It's the surrogate's health insurance that covers the surrogate. And so there needs to be a full review of the surrogate's health insurance to make sure that her health insurance actually will cover a pregnancy, even if she is acting as a surrogate, even if she's being compensated for that surrogacy. Many insurance policies will, but there are definitely some that won't. There are also some insurance policies that will put a lien on her compensation and say, you know, we are going to reimburse ourselves for the costs of your medical fees through your compensation. The way that families deal with that is not to then reduce her compensation, but rather they put additional money in escrow, because obviously the insurance company doesn't care if they're getting paid by the surrogate or by the intended parents. They just care that they're getting paid. But that is something that people need to be reviewing and checking to make sure that their coverage is sufficient. People also need to be making sure that their coverage is sufficient as years change, because insurance policies can change from one calendar year to the next. So people are often surprised when we say that surrogacy actually does have some seasonality to it. You see a lot of people trying to enter into surrogacy agreements in the fall during, you know, just before open enrollment, or during open enrollment, when the information is coming out about what next year's coverage will be. The nice thing about that is you can, you know, enroll the surrogate. If she doesn't have a surrogacy friendly policy, you can put her in a new policy that will be surrogacy friendly. And if you can get the pregnancy started right away, you can do your best to get that pregnancy maintained within 1 calendar year, which means only one out-of-pocket maximum. It means only one deductible. So it's kind of crazy to have to think about these things, but these are things that people think about. You also have to recognize that the surrogate's health insurance does not cover the baby when the baby's born. So because we have a parentage judgment before the baby is born that says these are the intended parents and this is the surrogate, she's not a parent, then she can't cover the child as her child under her health insurance because that's not her legal child. We can get a judgment before birth. In California, 7633 of the Family Code says you can get a judgment prior to birth and it'll just be stayed until the birth of the child. So as soon as that baby shows up, that baby is legally the child of the intended parents. The intended parents need to be reviewing their insurance to make sure that their insurance will cover their child immediately upon birth, even if neither of them is the one giving birth. This can be particularly complicated for international intended parents who might not have local health insurance in the state of California. Usually local health insurance requires proof of residency, which international parents might not be able to prove because they might not live here. They might just be coming here to pick up their baby and go back home. So obviously that can be a real source of concern when we're talking about things like you know, it might not be a simple labor and delivery. If you have NICU expenses, those can be exorbitantly expensive. So it's really, really important to make sure that you are considering that and making sure that they're getting proper insurance advice when they're going into it. And lastly, you know, just thinking about IVF coverage. So again, IVF is in vitro fertilization. I'm sure that there are many of you out there who have either yourselves or through friends and family seen the experience of IVF and how expensive it can be. And that is not necessarily covered by insurance in general, whether it's for LGBTQ couples or anyone else. And so obviously people who are dealing with that kind of concern and dealing with those expenses have to be prepared to pay for that out of pocket, because we have not yet gotten to a point in the United States or in the state of California where there is an insurance mandate that requires coverage for certain fertility treatments, including IVF. So those things can become very expensive and people need to be prepared. So I believe we have 1 minute left. If there are any questions.
I don't see any questions, but I just wanted to say thank you so much, Amira. That was really good information. And actually some of it I'm going to be emailing you about this afternoon for follow-up questions, but that was really great. One thing I did forget to do at the beginning was to thank our co-sponsor, Lydia Liberio from the inclusion section. So this was a co-sponsored event with the family formation and the inclusion section. So thank you so much. That was super informative. And I feel like we could break off so many pieces of that and do an entire other presentations on so many topics. So thank you.
Thank you.